Welcome to Part 5 of Bright Ideas, a PTI Nebraska workshop on special education law. In this part, we'll discuss a crucial step toward obtaining special education services for your child with a disability, granting your consent. In Part 1, we noted that placement of a child in special education begins with a referral to your local school system. The next step, before any child may be placed in a special education program, is for the school system's experts to perform an initial evaluation to determine whether your child is eligible to receive special education services and exactly what services the child requires. However, even before an evaluation may take place, the child's parent, or surrogate or guardian as we defined in Part 3, must consent to the evaluation. It's important to remember that you, as the child's parent, are in control of the process. Without your consent, your school system will not be able to offer special education services to your child. Withholding or revoking your consent is a powerful tool in your arsenal if you determine that the school is not providing the most appropriate services to your child. But withholding consent is not without its own consequences, which must be carefully considered. In the event that you either refuse or neglect to respond to your school's request for consent, the school district has the option to pursue an evaluation of your child under its child find obligation through its own procedural safeguards. In Nebraska, that means going through a formal process of dispute resolution. Remember that federal law requires the state education agency to make a reasonable effort to obtain your informed consent to an initial evaluation to determine whether your child is, by definition, a child with a disability. It's important to distinguish between your consent to an initial evaluation and your consent to initiate special education services. Your first consent is to an initial evaluation only, not the provision of services. In this case, there is little reason to withhold consent. An evaluation goes well beyond a simple screening by a teacher or specialist. It's a comprehensive examination of your child in several disciplines and at no cost to the parent. Regardless of the outcome, much useful information about your child will be learned through an initial evaluation. In the event that a child is a ward of the state, no consent is necessary if the parents can't be located or if the parents' rights have been legally terminated. No parental consent is needed either if a court-appointed third party representing the child grants consent. Once an initial evaluation has been performed and the multidisciplinary team has determined that a child is eligible for special education services, the local school district must return once more to the parents for consent, this time to begin providing services to the child. Unlike obtaining consent to an initial evaluation, if the parents refuse or do not respond to the request for consent to begin providing services, the school district may not take the issue through the dispute resolution process in order to force the issue. The child will simply not receive any special education services, and that's that. Because the school made reasonable effort to obtain consent for an initial evaluation, and again made the effort to obtain consent to begin services, the school cannot be held in violation of the requirement to make FAPE, the free, appropriate public education, available to the child. Neither do they need to convene an IEP meeting or develop an IEP document for the child. Once the parent declines or ignores the request for consent to provide initial services, the school system's responsibility to provide special education services to the child ends. Now, assuming that parental consent has been granted, once the school district has begun to provide special education services to the child, the parents may, at any time, revoke their consent. This must be done in a written letter to the school district rather than verbally. The consequences of revoking consent are largely the same as not granting consent in the first place. Before dropping the child from special education, the school district must first respond to the parents with a written notice of its intent to discontinue special education services to the child and then cease its services. Again, the school may not pursue an attempt to force the child back into special education services. And again, the school cannot be held in violation of FAPE, and no additional IEP meeting or document is necessary. Since the child will have already received services for some period of time, documents pertaining to these services will have become part of the child's permanent school records. The school cannot be required to remove these or any other references to special education from the child's records. Most importantly, in the event that parents do revoke consent for all services and then later change their minds, any existing evaluations are nullified, and the family must step back to the very beginning of the process and start all over again from the initial referral, with all of the attendant delays that will mount up before the child again receives services. As you can see, revocation of consent is something to be weighed very carefully. Let's say that the parent has granted consent to both the initial evaluation and the provision of services to the child. Now the child's evaluation must be re-examined at least every third year, or sooner if there's reason to suspect that the most recent evaluation doesn't represent a current picture of the child. And yes, parental consent is necessary for each of these re-evaluations as well. So here too, the parent has the opportunity to grant or withhold consent to the evaluation. However, in this case, since the child is already receiving services, some assumptions are made. First, since the parent has previously granted consent to an initial evaluation and to the provision of services, it's now deemed to be in the best interest of the child to more aggressively seek to continue those services. Therefore, if a parent refuses consent for a re-evaluation, the school is permitted to invoke its procedural safeguards and enter the dispute resolution process to attempt to override the parent's refusal of consent. And in the event that a parent simply doesn't respond to a consent request, in Nebraska, the child is going to continue to receive existing services with no new evaluation, as long as the district can show that the parent was non-responsive. We can't stress enough, though, that you should always respond, one way or the other, to any request from the school district for an evaluation or for any other consent. Don't simply be unresponsive. The law makes gaining parental consent an important part of the process of placing a child in a special education program. It's one that's protective of personal liberties. Refusing services or withholding consent can be a very powerful tool for parents, but the consequences can be serious. The point of a child's entry into the special education process is not the best time and place to withhold consent. Nor is it wise at any time to withhold or revoke consent affecting all services across the board, essentially removing your child from the special education process. A much better way to express your concerns is to become an active and informed participant on your child's multidisciplinary and IEP teams. In that way, you're best able to influence the direction of your child's education, and you'll be able to refuse one service without affecting any of the others your child may receive. You are an important part of your child's IEP team. You know your child best. If you're going to refuse services or revoke consent, bear in mind that it must be done in writing in a letter to the school district. Also note that when the school merely wants to review existing data as a part of an evaluation or a reevaluation, no parental consent is required. Only the gathering of new data about your child requires your consent. And remember that consent for an evaluation is not the same as an agreement for your child to receive services. The Individuals with Disabilities Education Act contains numerous protections which ensure that every child, regardless of disability, receives a free, appropriate public education. By revoking your consent or refusing services, you remove from your child all of those protections that are in the federal law. Your child will be subject to the same academic and behavioral expectations as all other children. You are always in control of your child's education. It's your decision, but it's not a decision to be taken lightly. This brings to a close Part 5 of Bright Ideas. Part 6 begins to take us step by step through the special education process in greater detail.